Imagine endless reality TV storylines with new cast trajectories, unbelievable drama, and enhanced challenges, all courtesy of AI. Due to the broad rights granted to studios by show participants to their name, image, likeness, along with personal access and editing rights, this could be a real possibility. So, what are the legal, ethical, and reputational risks of using artificial intelligence in reality television? And what balance can be achieved between the goals, the studios, and the rights of the talent? Artificial intelligence has great potential, but even with the talent contracts in place, there are very real legal risks to consider. They involve copyright infringement, regulatory issues, the right of publicity, defamation, the future technology provision, and labor and union issues. It seems like every day a new AI lawsuit is making headlines, especially around the issue of copyright. In Anderson versus Stability AI, visual artists allege copyright infringement and other claims based on the creation and function of Stability's generative AI tool. The case is currently still active, but the court has noted that precedent is thin and may not be that influential given the vast differences in AI models and the types of copyrighted works. Additionally, claims may be tough to prove given the variety of user input and the AI's output in response. Despite uncertainty in the courtrooms, the U.S. Copyright Office affirmed the long-standing principle that copyright protection is reserved for works of human authorship. The Copyright Office also makes it clear that text and image creating prompts alone are insufficient to attribute ownership rights, because it is not possible to predict what the tool will create ahead of time. Therefore, the human lacks sufficient control over the final product. The Copyright Office does, however, separate the AI-generated components from the final work rather than analyzing it as a whole. AI is going to test the limits of the talent contracts. California courts in particular are already skeptical about waiving away liability for certain harms. Deepfakes of a cast member may trigger claims of invasion of privacy and violation of the right of publicity. The ETW versus Jire Publishing case confirmed the right of publicity as an inherent personal property right, intended to protect a celebrity's image from purely commercial use of their image. Although the outcome indicated limitations, the right of publicity protects a celebrity from having their name, image, or likeness used for the purposes of advertising or selling without their permission. The right of publicity covers more than just the physicality or name of a celebrity. Violations can stem from the use of a celebrity's catchphrase.
And now, ladies and gentlemen, here's Johnny.
Or mimicking their voice with a sound alike to give the impression a celebrity like Bette Midler is singing in a Ford commercial.
Do you wanna dance and hold my hand?
Or even using a non-human look-alike, similar to how Samsung created a robot Vanna White to advertise its electronics. One recent sound-alike raising questions involves OpenAI's chatbot Sky that sounded uncannily like actress Scarlett Johansson, who voiced an AI character in the movie Her.
Hello, I'm here.
Oh.
She publicly denounced the use and OpenAI removed the voice. No case has been filed, but a congressional subcommittee did invite Johansson to testify. What about using AI to rearrange or create new content from completed episodes or old footage of participants? In de Havilland versus FX Networks, actress Olivia de Havilland sued over the depiction of her in the miniseries Feud. The court stated whether a person portrayed in one of these expressive works is a world-renowned movie star or a living legend or a person no one knows, she or he does not own history or have the legal right to control, dictate, approve, disapprove, or veto the creator's portrayal of actual people. Reality talent agreements may very well then allow for the use of AI with previous footage or information involving the talent under the editing or modifying provisions. Right of publicity is geared towards celebrities, but the metrics for celebrity are changing as the line between being a private and public figure blur. A Florida court found there to be a split between the public and private persona in a case involving the famous wrestler and reality TV star Hulk Hogan. who sued Gawker under his birth name Terry Bollea for the unauthorized release of a sex tape. The court found that Terry retained his right to privacy because it was his public persona of Hulk Hogan who was the overtly sexual one, not the plaintiff in his private capacity. It is unclear whether this argument for someone of Hogan's notoriety can successfully be argued outside of Florida, but if that duality is recognized, then using AI on a cast member within a reality show could cut in favor of the studio, as the cast member's TV personality could be deemed a character. In response to lawsuits from family members of deceased celebrities like George Carlin, who appeared in an unauthorized AI-created comedy special, many state legislatures have extended a post-mortem right of publicity. As you can see, AI is forcing previous parameters and protections in the business to adapt. And the defamation waiver in talent contracts will be another area of the law tested by AI usage. Some courts uphold the waiver in reality TV contracts and don't consider the merits of the case, while other courts disregard the waiver and focus on the truth or falsity of the comments themselves. In June of 2023, radio host Mark Walters filed the first defamation case against OpenAI after ChatGPT generated false allegations against him in response to a journalist's question to provide a summary of pending lawsuits. In its response, ChatGPT indicated that Walters was accused of fraud and embezzlement, all of which was untrue. Historically, studios have relied on a future technology clause to protect for uses unknown at the time of contracting. The clause is broad and typically stipulates some example of additional platform usage, like online, streaming, or interactive. But it's also left open-ended with clauses like in all media worldwide now known or known hereafter in perpetuity in this universe and all universes unknown. Video cassettes, DVDs, DVRs, and streaming all incited litigation when they debuted. Courts have generally held that if a party has agreed to a broad future tech clause, extending the media developed thereafter, the other party can hardly avoid the contract's application by establishing that the precise nature of the advance was unforeseen. But some Ninth Circuit courts have held the phrase, by any means or method now known or hereafter developed, may not be sufficient to ensure that all newly developed technologies are covered. And other courts look to the intent of the parties. But if the tech is completely unknown at contract signing, it is hard to enforce. Some legal scholars make a distinction between a technological breakthrough and a new means of distribution for the tech in question. The judge in Anderson versus Stability AI, which I spoke about earlier, distinguished AI from VCRs and how each uses and disseminates the material in question, stating the VCR did not ingest and come pre-programmed with copy-protected content, unlike generative AI. Much of the AI debate in Hollywood has centered on protecting unionized performers. After a lengthy strike, SAG-AFTRA was able to secure protections for their members in regards to AI usage with consent, compensation, and control stipulations. But reality TV participants are not union members, and many are independent contractors. Since the strike, though, there has been a swell of calls to unionize reality talent, and SAG-AFTRA has not ruled the possibility out. Unionization among unscripted TV casts would restrict what a production company can and cannot do to find, finesse, and manage reality TV stars. It would not only change the business, it could alter the content. In a step to protect non-union performers, California passed Assembly Bill 2602, which requires informed consent and legal or union representation in regards to the creation of a digital replica. It also requires clear and reasonably specific descriptions of the intended use at the time of contracting. The law is effective only as it relates to performances after January 1, 2025. Industry-wide standards and compliance should be encouraged. Labeling or watermarking content as made using AI is a first step. The Authors Guild has an official certification system. The Archival Producers Alliance created a Guide for Best Practices for Use of Generative AI in Documentaries, and YouTube is expanding its pilot program designed to identify and manage AI-generated content that features the likeness of creators, artists, and other influential figures. New contract terms will be needed to secure rights for digital replicas, for voice and likeness rights, and customary language such as all media known or hereafter devised will need to be tweaked. New contractual language will also be needed to address digital twins. Digital replicas can originate from the studio or from the talent themselves. Going back to the split between private and public persona from the Hulk Hogan case, the control and ownership of the digital twin could pose significant issues for a media outlet. If the cast member is under contract, who owns the digital twin? Does the digital twin have a right of publicity? Would a digital twin show up on a background check? What kind of recourse would the studio have against the real-life cast member for actions or violations of their digital twin? All this would need to be defined and enumerated. Any use of AI in the creation of a new or alternate reality series would also need to be accompanied by documented significant human contribution. Otherwise, the property would be ripe for infringement.